So we are going to begin with the healthcare power of attorney. So again, if you've downloaded your forms, if not, go ahead and do it. If not, no worries. But we're going to, Tiffany is here to guide us through this. So if you could kind of give us a brief explanation of what it is and why it's important.
Yep.
And then we're going to get to preparing them.
Awesome. We're going to start, as Janai said, with the medical power of attorney. That can also be called, and I hate that we have so many words for these things, but in some states it's called something, some states it's called something else. But if you hear the term medical power of attorney, or you hear the term healthcare directive, or you hear the term advance directive, or you hear the term living will, those are all types of the same document. It is your medical power of attorney. So when you hear living, sometimes people will say living will when they really mean trust. A living will is the same as that healthcare directive or that medical power of attorney. So those names are synonymous. Also in the definitions as we talk about this, let's discuss what a principal is. So when you see these documents, you'll see the word principal often. The word principal is the person who is creating the document. So each one of you at home, when you're doing this, you are the principal. The word agent is the person that you are nominating to make the decisions for you. So there's the principal and there's the agent. The principal is the person creating the document. The agent is the person that you are nominating. As we said before, these documents can be revocable. So like we were just discussing, if you change your mind down the line, you can do these documents again and it'll revoke any previous ones. You can literally write down on the paper later, revoked, and then that would revoke it as well. So don't stress yourself trying to think of the perfect person now. Think about what's right for you and your family at this current space, and you can always change it later down the line. So you as the principal, so states vary on this as well. So can anybody do a power of attorney? Great thing about Janai is she called me one day and she's like, you know what? I think my kids need to do this too. Yeah. And I said, yeah, absolutely.
I had my kids do it.
Yeah. So it varies age-wise in states. So in Georgia, you have to just be 14 to be able to do a power of attorney, a will, a trust. 14. Yeah. Many states, New York, Florida, they all say 18, but Georgia allows 14.
Wow.
And there may be some other southern states that allow a younger age, but that you also need to make sure that you verify with your state how old you have to be. But most of the times, just for safety purposes, just go with 18. Also, most states are going to require that the principal, the person filling out the form, is of sound mind. So what does that mean? It means you understand the nature and the scope and the extent of what it is you're writing on this paper. So unfortunately, if you are in a coma, it's too late. If you're in a vegetative state, it's too late because you are not of sound mind. I get a lot of calls where a potential client will say, well, my parents need to do these documents so that they can name me, but they're in a vegetative state. That's not going to work because they are not of sound mind. Also,
Tiffany, just to interrupt you,
sure.
Obviously that must be a huge issue for dementia.
Absolutely.
Okay. So
absolutely.
You have to get in front of that.
Absolutely.
Yeah. For you who are caring for your grandparents or your parents.
Right.
Yeah. Annie's shaking her head. So you had to take care of that with your mother?
Oh, we did.
Yeah.
Okay. Her mother has early stages of dementia.
Right.
Yeah.
And there are times where people can be lucid. So they are of sound mind, even though they might have dementia. And that means we can get it done right then and there. So I've had that many times where I will sit with the client. I will talk to them for a good 30 minutes. And I'll be like, how are your kids doing? What did you do last summer? Just to get the questions and the answers to make sure that they understand what it is that they are talking about and they're doing.
Okay.
Let's talk about who would be a good agent. So that's the person that you are nominating to make decisions for you. Number one, obviously it's going to be someone that you trust, obviously someone you know. It could be, like I said, there are corporations who will serve in this role. But if you want it to be a family member, someone you trust, someone you know, someone, especially when it comes to these healthcare power of attorneys, someone who can make really tough decisions under really tough scenarios. Yeah. So under stress, under duress, they're still like cognizant, they're smooth, they can make really tough decisions.
Steady, very steady people, right?
Someone who understands you. someone who knows you, who knows your values, who knows your philosophies, who knows how it is that you would treat your children or your loved ones. That's really important. And I would say the number one thing is someone who is available and someone who is willing to act. Like you said, you better tell me because I'm going to need to know.
Right.
The other thing I get often is, I want to name a loved one or a friend, but they live in Germany. What good does that do if you are in a hospital in the middle of the night and someone needs to be there like that? So someone who is available and can act. That's a big one, huge one, because your trusted family members might not be local. And it's not that they have to be local, but they need to be able to get there to make decisions quickly. So that's a big one too.
So I'm looking at my Georgia form. So I listed my husband as my healthcare agent. That's the term. And then on the next page, my backup healthcare agents. I have space for 2 people. So you can have more than one person act?
Absolutely.
Okay.
That's another great point. You can have co-agents. So you can name, both your parents, or you can name 2 friends, or you can name your spouse and your mom. The only thing that I would say you should think about there is that you're asking 2 people to agree to something under a very, very tough scenario.
Right.
I have a question.
Okay, question.
Ani has a question in the background over here.
So that is my exact situation.
Yeah.
Mine needs to change now because of my mother's circumstances changed. But when we initially did it, I guess my philosophy was, if you're both in duress, that maybe there's some calm between the 2. That I don't think they would be falling on the floor.
Right.
Obviously I wouldn't have named them if that was the case, but that can bounce something off a sound decision to make. So, and they get along. So
Great.
again, it wasn't a hostile situation, but I do understand your point,
Yeah.
because you have to be able to. Because my husband kind of felt some kind of way initially. He's like, "You don't think I can make a sound
Exactly.
decision?" Right. And I was like, that's not what I said.
Right.
Right.
So but that obviously will change for me because I need to update based on the circumstances. But that's a point. And now a life event has happened.
Right.
And I have to update my forms.
Right. It's also interesting too. Some people will not nominate their spouses or their parents because they'll say, you know what, they're going to try and keep me alive as long as possible.
Right.
And that's
And I
not
don't
what I
want that.
want.
Yeah.
That's not what I want at all.
Right.
They're going to try because they love me so much, but that's probably not the right decision.
Right.
So thinking about that and taking that into consideration too.
Okay. So pick your agents wisely, people.
Yeah.
Yeah.
So the next quick summary item is kind of, when do these documents become effective? So there are a couple different ways that they can become effective. One, they can become effective upon the day you sign it. Some states will allow you to put in a later date if you wanted to. I have never in my entire career done that, but there might be a reason why you would want to do that. I'm just like, I don't know what's going to happen tomorrow. I could walk out this door right now and something could happen. So usually we are doing the medical power of attorney as an effective date upon signing. But it can be effective at a later date if you choose to. And again, most of these medical power of attorneys, when you're nominating an agent to make healthcare decisions for you, those healthcare decisions and those people are not coming into effect until you cannot make those decisions for yourself. Or they're coming into effect when a doctor has deemed you almost terminally ill. Like it's not getting better for you. A doctor has done everything in their power to get you to a place where you can come back from this, and they're saying, no, it's not happening. That's usually when these documents are coming into play. So that could be vegetative states. It could be terminally irreversible conditions. It could be comas, things like that. Think about those as the scenarios and when these documents are coming into place. And again, remember I said you can likely revoke them, so don't feel as though if you do it today, you can never pick different people.
And so those of you who are not in Georgia, your document is not going to be exactly in this order,
Correct.
Potentially. However, the points that we're going to cover are pretty universal, I'm assuming?
Absolutely.
Okay.
And we'll go through the other form that kind of covers California, New York, Florida, DC, Missouri. We have another one that we can go through, but I think we'll start with Georgia, and we'll see a lot of similarities when we get to the other form.
Okay. So I know we've already been talking an hour, ladies, and but this is really, really important.
Yeah.
And I don't know where you're going to be able to get this level of help and direction on such important documents for absolutely positively free. So if you need to go use the bathroom, come back, get some water, but I need you to settle in because we need to finish this today.
Yes.
So I want us just to really kind of hang in there and we get this done today. Let's make this commitment to each other that we're going to knock this out.
Let's do it.
Yeah.
All right, so we're going to look at the Georgia Advanced Directive for Healthcare. So this is that form. I'm not sure if you can see it on the screen.
Right.
So again, as you can see, title, a little bit different than medical power of attorney. It's called the Georgia Advanced Directive for Healthcare, but it is the same thing. It's just a synonymous name. The first line says by, client name. So that is where you are putting your name. You are the principal. So you're putting your own name right there where it says by. You will then, to the right of that, put your date of birth.
So remember, you're doing this form for yourself.
Correct.
Unless you're helping your mom or your grandmother or somebody.
And then part 1 that we're going to get to now is where you are nominating your agent. So let's go down to part 1. You'll see right there, number 1, healthcare agent. I select the following person as my healthcare agent to make healthcare decisions for me. So you would go ahead and put the name right in that first block. And if you have 2 people, so let's say you want to name 2 people, you can go ahead and just write in, or you can kind of copy and paste that entire block, that name, address, telephone block, and stick it in again right underneath it. So you could do that if you want to name 2 people. Another option if you want to name 2 people is just put 2 names on that first name line. On address, you are going to put your agent's address. Again, if you have 2 agents, you would put 2 addresses in that line. Next up, you're going to put telephone number. The numbers that you have, I recommend if you've got a mobile number, put that number in there for your agent. We're going to flip the page. This section 2 is what is entitled Backup Healthcare Agent. So this comes into effect if the person or persons you named in number 1 are unable to serve, or if they get called and they're like, you know what, I don't want to do this. I decline. Then we need a backup. Who is going to be backup to that first person or persons that you've named? And again, you could put 2 people here. You could put 3 people here. You can even put a succession. So you can say, if Jane says no, then I want John. If John says no, then I want Janai. So you can kind of put a line down as well. And to do that, you're going to go ahead and put the name, address, telephone number for those people. And if you look right above, you'll see some boxes. The first box says, each to act successively in the order named. So that would be that kind of succession that I just told you. Jane, then John, then Janai. Or you can click the second box that you want them to act together. Or if one is unable to act, then the second one. So let's say you put Jane in that first box and you put John in that second box and you initial that second line. That means Jane and John are acting together, or one of them alone if the other is unwilling to act or unable to act.
Yeah. And so, ladies, regardless of what state you have, again, it may not look exactly like this, but this information is within your forms.
Correct.
So go ahead and flip to the page that applies to you. And then that way, if you know, you can jot in that information. If not, you can go ahead and start thinking about who you'd like to act.
Right. Now, below that, that's section 3, General Powers of Healthcare Agent. This is basically just a summary of what authority you are giving your agent. So you, the principal, are saying, my agent, Jane, John, or Janai, or all 3, could admit you, discharge you from a hospital. They could consent or withhold or withdraw any type of health care. They can work with your healthcare facilities. They can be in the ambulance with you. They can get information about your healthcare. It's just a summary of all of the stuff that you are authorizing them to do. So that's that section 3. Section 4. This is an important aspect of this particular document in Georgia. What this section 4 is saying is that even though you are nominating these people, and even though as we go through this form, you are going to designate what it is and how it is you want your end of life to go, this section 4, and this applies in Georgia, it doesn't apply in every state, says even though you're going to dictate and direct them on how you want your end of life to go, they still have the final say so. So you could write down here, I don't want nutrition. I don't want you to prolong my life. And the buck stops with them. They can say, you know what, she wrote this, but I disagree. Yes. So what's interesting is you'll see again that title, Georgia Directive. It's a direction. It's not a requirement. And this is not the same for every single state. So some states, if you're doing one of their medical power of attorneys or their living wills, what you write is law. But Georgia, it is not. It's just a direction. This is what I would like. I hope you follow it. So that's also big. That's what that section 4 is saying. Section 5, again, this is a quirky Georgia thing, is that this whole entire section is kind of written in the negative. So here you are only initialing, and we'll go through each one of them, if you do not want your agent to have these powers.
If you don't.
Okay. If you do want your agent to have these powers, you're keeping most of these, A, B, C, blank.
I kept thinking, why are these blank on my form? I was worried because my form is blank for this page. Yeah. Okay. Now that makes sense.
So section A is autopsy. So if you do not want your agent to have the right to authorize an autopsy, then you would initial it. If you're fine with them having the right to authorize an autopsy, you leave it blank. I will let you know that in most states, there will be a required autopsy under certain circumstances. So for example, drug overdose, murder, things like that, the state or the police department's going to require an autopsy.
Right.
Second, B, organ donation and donation of your body. So here, you would initial next to each one of these statements if you do not want your agent to have the power to dispose of your body, using it for science, using it to donate your organs. This is where you would initial if you do not want them to do that.
So first, who knew that you had to make all these decisions? Tiana's face is like, what in the world?
Yeah.
But you literally are making some major decisions. Wow.
Yeah.
Ani has raised her hand.
Does it matter what's on your license as
that
relates to organ donation?
Very good question. That is going to be the first place that someone looks, so that when the police pull over or something and they've got your body, they're going to look at your license. This document will trump it, though.
Okay.
Yeah. But inevitably, there's a lot of, well, this is what happens, but practically something else happens. Usually they're looking at the license and they have not even gotten to the point where they get this document. Right. So usually your license is going to be what people are looking at for that organ donation part. Section C, final disposition of body. So this is like burial or cremation. Who has the right to make these decisions? If you want it to be someone other than your agent, you could initial that first section and put that person's information in. So if you say, you know what, I want my healthcare agent to be my spouse, but I want my mom to decide where and how I'm buried or cremated, you can name someone else there.
Is that not addressed in your will?
It can also be addressed in your will.
Okay.
Yeah. I often will, when I'm drafting documents, I will reiterate this in the will.
Okay.
But some people don't put it in the will.
Okay.
And then if you know whether or not you want to be buried or cremated, you would initial next to either one of those sections. Buried or cremated, if you know, go ahead and initial next to one of those.
One thing I just wanted to add about that is I don't think people understand how big of an issue this is when people pass away. the one person has shared what they want. However, the parents, the grandparents have a completely different belief,
Right.
and they don't want it to happen.
Right.
Please make the decision and have these forms done and share your wishes, so it is not some big, crazy, ugly issue within your family.
Correct. Absolutely. I can't stress that enough. All right, let's go to part 2. This is where it gets real.
Okay.
Real deal, Holyfield.
Go ahead and go get some wine for this part right here. You're going to need a little wine for this section.
So this is your end-of-life treatment preferences. So remember again, a doctor has done everything they can do. You are going to die. Remember that when you're filling this part out. You are going to die. Again, you are going to die. So think about that when you're filling this out. This section 6, I think, is kind of ridiculous, to be honest. If I was a Georgia legislation professional, I would change this section. So this section 6 says, here are the conditions in which you may be in where you know you're going to die. So the first one is a terminal condition, which means you have an incurable, irreversible condition that will result in your death in a relatively short period of time.
Okay.
The second one, a state of permanent unconsciousness, which means that you're in an incurable, irreversible condition. So you're not coming back from it. You're showing no behavioral response to your environment. So what this section is saying is, I want my treatment preferences of section 7 to come into effect in either one or both of these scenarios. And I think it's kind of ridiculous because no one knows.
Right.
Who knows what state I'm going to be in? So what I tell clients all the time is initial both, because you don't know. You don't know what the issue may be. So you would initial both of those sections, the terminal condition and the state of permanent unconsciousness. Now, this section 7 is what you want to happen in either one of those states. So you're in a terminal condition or you're a state of permanent unconsciousness. How do you want to be treated? And I want you to think of this as kind of like a line. So A is totally on the left, C totally on the right. A is saying, extend my life as long as possible. Do everything. Give me medications, give me machines, give me more medical procedures. I want to be able to take nutrition. I want fluid. I want pain medication. Give me everything. That's A. B is kind of that middle ground. So it's saying, allow my natural death to occur. So I don't want medications. I don't want machines. I don't want more procedures that could keep me alive but not actually cure me because I'm going to die. But B says, I do want to make sure that I'm not in pain. So you can give me nutrition or fluid just to make sure that I'm not in pain, or pain meds to make sure I'm not in pain. But allow me to die naturally. No more procedures, no more machines, none of that stuff. Mm-hmm. C is saying, I don't want anything. Don't give me medications. Don't give me machines. Don't do any procedures. Don't give me fluid. Don't give me nutrition. Nothing. That's C. That's that whole other side. What Georgia allows, though, under C, because they think C, I guess, is kind of the extreme, is that you can kind of a la carte if you wanted something.
Which one you want?
Right.
A la carte,
yeah.
You got out.
Oh, wow.
So if you, let's say you don't want medications, machines, but you might want a ventilator, which is actually a big one, especially now during the pandemic. We've had a lot of clients who may have in the past said, never do I want to be on a ventilator.
Right.
And you might change that now.
Right.
Because
right.
that is a big deal in this COVID environment.
Right.
So, and this is not to dissuade anybody here, but I will let you know in my entire practice that most people and most doctors choose B.
Yeah. I have B on mine. Yeah, just some people. Yeah, no, I selected B.
Yeah.
I think David did too.
I have B on mine
Yeah,
as
B
well.
on mine. Yeah.
So again, you under section 6 are going to initial both of those. Under section 7, you will initial A, B, or C. And if you want some a la carte things under C, you could initial next to one of those. The other option is to leave the whole thing blank and let your agent decide. That's another option.
So again, ladies, regardless of your state, please make sure you're looking at your forms because, again, the questions have to be similar where you're going to have to make a decision what type of medical care you want. So please select that.
Right. Section 8 in the Georgia form is additional statements. Here you can kind of write anything. This comes up quite a bit with religious preferences. So if you have a particular way, like for example, in the Muslim faith where you've got a cloth that you need to be wrapped in, things like that you could write here, or you could state any specific burial procedures that you want. I want to be cremated. I've got that I want my ashes spread across Jamaica, things like that, that you could write kind of just in that additional statement section. You don't have to write anything there. You can, completely up to you.
Can I read what's in mine?
Sure.
This is from the advice of Tiffany. So mine says, I expressly permit my medical professionals to communicate with my healthcare agent electronically via FaceTime, Zoom, or other means. I further permit my healthcare agent to authorize the use of a ventilator for COVID-19 and COVID-19 related illnesses.
Yeah.
So obviously I just did mine. I did my forms October of 2020. So we were in the height of COVID. And I did not want to, if I have COVID, I do want to be on a ventilator.
Yeah.
So don't read the form. Don't allow my husband to be like, she don't want a ventilator. No, I want to be on a ventilator. But because of technology, I want them to be able to talk to him via Zoom or FaceTime or whatever else, because you think people could not go into the hospital. Yep. So that's my little comment there.
Perfect. That was a good add here. Section 9. This is in case of pregnancy. So we've got all the ladies on the line. This is basically stating that our section, let me look at it again, Part 2, Section 7, it all goes out the window if we need to keep the baby alive. That's basically what that section says. You would initial where that little box where it says initials if you want Part 2 to continue. So that would mean, let's say, God forbid, you are pregnant, you are in the hospital, the doctor says we can't keep you alive. You've initialed B on that section and you say, I don't want machines, I don't want procedures, I don't want any of that stuff. What we're saying here is scratch all of that. Save the baby. Do everything you can to save the baby. You would only initial here if you do not want that to apply. So you're saying, go ahead, B needs to stand regardless of whether or not I'm pregnant. So you would leave it blank. Again, if you want to do everything possible, medically possible to save a child, you would initial it if you do not. Part 3, guardianship.
This is a big one.
This is another big one. I want you guys to think Britney Spears.
Right. Right.
So if there's ever an instance where someone needs to care for your body, to take care of you, again, we've got elderly parents, elderly grandparents, where they can't actually take care of their own body.
Right.
Sometimes a court will appoint a guardian in those instances. And here, Section A says, I nominate the person that I nominated in Section 1 as my agent to be my guardian, period. Section B says, I nominate the following person. So you could nominate someone else other than the agent that you named in Section 1. Most people are going to initial next to A. They want their same agent to be also their guardian. All right, Part 4, we're at the end of this form. So this is effectiveness and signature. So here, remember I was saying some states allow you to have the form be effective upon a later date. That's what that middle section is saying. It says this advance directive for my healthcare would become effective on or upon blank and will terminate on or upon blank. So you could, if you wanted to, put in when you want it to be effective and when you want it to terminate. If you want it effective today, you leave that blank and you just sign and get it witnessed. I do not want you guys signing these today because you need your witnesses to see you sign. Yeah. So let's be very clear there. We're just going through this form but your witnesses need to watch you physically sign. And in most states, they need to be in the same room with you. Okay. So don't sign it tonight. Go ahead and fill it out, reread it, think about it. Only sign when you've got your 2 witnesses in front of you. So again, if you sign and date it, it's effective today. If you wanted it effective upon a later date, you could write that in. And I will tell you that I do get creative with drafting these sometimes. So, for example, I may have a spouse as the agent, but that spouse is overruled if the child is a certain age. So there's ways to be creative with this too. So for example, you could say, I name my mother, but if my mother lives in New York at the time I need this, then I name this person. You can be very creative here.
That's interesting.
Yeah.
So ladies, if you have any questions again about your state, please ask, because it's really important that you make the commitment to get these forms completed and then schedule the time to get them witnessed,
yes,
notarized, and put someplace safe, because we're going to make sure we get this done in August. We're going to get it done. Oh, another question.
2 more questions.
Okay.
Kimberly asks, in Alabama, I don't see a section for guardianship of my body. Would I add that in the other directions section?
You can, absolutely. You can put that in the other directions section. You could also put that in a will if you're drafting a will. I know that's not the topic today, but I think for safety reasons, just put it in the additional statement section.
Great question.
And Luell asks, can we go back over section 10?
Sure.
The guardianship.
Section 10.
Section 10, guardianship. So this is nominating someone who is going to take care of your body. So think of the actual person, the bathing, the brushing the teeth, the actually taking care of yourself. So in this, Section A says that you can nominate the person that you nominated as your agent to also serve as your guardian if a guardian is needed. So if a guardian is not needed, it's fine. This does not come into effect. But if a guardian is needed, you can nominate the person you named as an agent under Section A, so you would initial there. Or if you wanted someone else, you would initial next to B and put that person's contact information in.
So in this situation, so it sounds like you were actually very sick.
Yes.
Maybe you were in an accident. You can't take care of yourself.
Correct.
So someone has to help you.
Correct.
This means you could potentially get better, though. This area does not mean that you're going to pass away.
Correct.
But in the meantime, until you can get up on your feet and able to take care of yourself again, this is who's going to be that person.
Absolutely.
Okay.
Exactly.
So make sure that they have the skill set.
Yes.
Yeah, that's important. You don't want to pick people who this is not their gift.
Right.
You
so
know?
not their ministry.
Not their ministry. Not the ministry.
The first visual I got was the Tyler Perry movie when the wife is taking care of the husband after he tries to leave her and she's beating him up with the...
Oh, goodness.
I don't know if you remember that.
I do remember that.
Beating him up because he treated her so awfully,
He treated her
but
so
she has
bad.
to be the one to take care of him.
Right.
So.
Back to choose wisely.
Exactly.
Right.
Exactly.
So great questions, ladies. Oh,
And yeah, we have Gina. Shout out to Gina.
Okay.
She said, if anyone on this Zoom that lives near Tampa or surrounding areas, I will notarize their forms for
look
free.
at that.
Just contact me and mention thank me later.
That's awesome.
Thank you.
Look at that.
Gina, we
Shout out
appreciate
to you,
that.
Gina.
What a community.
Yeah, well, we appreciate that. But please, ladies, you've got to schedule the time to get them notarized and witnessed. Okay?
Yeah.
Please do that. So you good on?
Yeah, I want to quickly, it's going to
Okay.
be very quick.
Okay.
There's another form on there, advanced. It's got a lot of highlights and stuff. This form is a medical power of attorney, but it can work for Arizona, Missouri, D.C., California, New York, Georgia, Florida, Illinois. I don't know if we can bring that one up.
Hold, please.
Okay.
Yes.
Ani said, hold, please. We're bringing that one up.
So I just want to kind of show you where it matches what we went through on the Georgia one, so you can kind of see the same similarities.
And so while Ani's pulling that up, is there a reason why you would select that form that covers multiple states versus just a Georgia form or a New York form or just a California form?
I would recommend that if your state has a state form, that you follow that one. For purposes of our conversation today and for purposes of having clientele that kind of reach many, many states, we as a firm put together a form that could work for many different states. Okay. But I will say that doctors are more used to seeing their state-specific form. Okay. So I would recommend that if you've got the links to the state-specific forms, that you use that one. But you can also use this one. It's just a little bit more general.
Okay. Anything that you want to start addressing until they pull the form up?
So you will see in this document a lot of highlights. I don't want it to scare you. Okay. Again.
Don't be scared.
Yeah, this is a form that our firm put together to kind of touch many states. So you'll see there's a lot of highlights and places where you can delete, where you can leave language in. You'll see use this if you do that, or don't use this paragraph if you use this. So you'll see kind of prompts throughout this document. A lot of the highlights, though, are really just plurals. So, for example, if you name two people, you're going to use the plural of an adjective versus in verbs differently. So you'll see a lot of that. Most of the highlights is the plural attorneys, in fact, instead of just attorney, in fact, or is, or are instead of just is. So things like that.
So, ladies, we're going to make sure that this form not only gets added to the chat, but we will make sure that it's posted out there for you in the Thank Me Later community, because we want to make sure that you have access to that. But remember what Tiffany just said. If you have a choice, please use your state-specific form first. That should be your first choice. Then this form is secondary.
Correct.
And that would make sense, because you don't want any discussion with the hospital or the doctor, because the form looks a little foreign to them. Right. They're used to, just kind of the standard form.
Absolutely.
Yeah.
So I think we're about to pull it up. So here you'll see advance blank for the state. Here we've got California. You could put your state there. Medical directive of you, the client name. So you are putting your client name there. So you're just going to delete those little arrows and you client name, put your information in there. And again, that first paragraph, you putting your name in there, a resident of your county, your state. Declare this instrument to be and here we have advanced medical directive, or you could delete the word advanced based on your state, medical directive, and durable power of attorney for healthcare decisions. So section 1 is a statement of intent. Here is kind of just a statement that basically says you're of 18 years of age, you are voluntarily and willingly making these decisions, you are just kind of setting the stage. So you could leave that in there, you could delete it if you want, you could change some language if you wanted. It's just kind of this is what I'm doing. I understand the nature and scope of what I'm doing, and I understand the people it is that I'm naming. We also have here a section for Catholic faith. If any of you are Catholic, if you want to keep that paragraph in, you can. Keep going down. And section 2. This is very much like the section 7 in Georgia. So this is where you're naming your treatment preferences. That broadest option, section 2.1, is what you would leave, and you could edit it a little bit if you wanted to. This is basically saying, if I'm in any one of these scenarios, A, B, C, D, so for example, I'm substantial brain damage, brain disease, dementia, coma, persistent vegetative state, my physician reasonably believes it's irreversible. These are those same things that we went through on that Georgia document. Section 2.1, that broadest option, you would leave all this language here if you do not want people to prolong your life. Again, this is don't give me medicines, don't give me machines, don't prolong my life. That's that section 2.1. Broadest option. Section 2.2. This is like that section B on the Georgia form, that middle option. First sentence says, I want efforts made to prolong my life, and I want life-prolonging procedures to be provided unless I am in a coma or persistent vegetative state and my physician reasonably believes it to be irreversible. Again, so that's that middle section. Here you'll also see in some highlights that you can put possibly wanting nutrition, hydration. You can make those decisions under that section 2.2. That's that middle option. Section 2.3 is a living will declaration. And the most limited option, which is that prolonging your life if you need to be. So these are all of your options, very much like that Georgia form. So that, you would just have to kind of read through it, delete anything that you don't want or any paragraphs that you don't want.
I can tell you this. I'm not going to speak for anyone else. I feel a little bit more confident with the Georgia form.
Yeah.
Just because it's shorter
Yeah.
and it's not, the bunch of deleting. I feel more confident that I can answer the questions
Right.
versus editing. So those of you who are in other states, don't feel intimidated by this. Check out your state's form to see if that suits you better.
Yeah.
Because, again, the goal is just to get this completed and, you can check this box to make sure that you're good.
Right.
Tiffany, can you confirm what were the states that form applied to again?
So this form can be used in Arizona, Missouri, D.C., which is not a state, but D.C., California, New York, Florida, Illinois.
Gotcha. Thank you.
That's a lot.
Yeah.
So we've covered a lot.
And that's why this form is a little bit more robust, is because we had to cover so many different states.
And so, ladies, please feel free to share this with your loved ones. So
Yes.
we want to make sure that you all are good, but we know that you're better when the people around you that you're going to be in charge of, that they have their stuff together too.
Right.
So encourage them to pull their state forms down, or again, please feel free to share this. Maybe y'all can have a form completing party.
Yes.
Yeah, maybe y'all can do that, but definitely want y'all to get these done.
Right. And then we're going to scroll down to that section 3.1. This is where you're actually naming the person. And most of the highlights here, again, I don't want you to be overwhelmed, are literally just plural. So you'll see is or are or the S on the end, or serving jointly or serving alone. Most of the highlights here are not legal. They're just whether or not you have two people acting together. So don't want you to get overwhelmed there.
Jennifer asks, can we use the form in Virginia and Alabama?
I don't have and we'll get to the end. The end is the kind of the most important. It's the execution requirements that are needed for every state that I named. I actually have in this document, so you don't have to go searching for it. I don't have that for Alabama. So it's not that you cannot use this form. It's just the signing, whether or not you need witnesses, whether you need notary, that's not already prepared for you in this form.
So again, please use the link that we provided on the invite for your particular state, or if your state was not specifically listed, where all the other states are.
Right.
So we try to help get as many of you. It is a challenge because you all are all over the United States. So we couldn't have forms for every single one, but again, please use those links.
Yeah. Also, just wanted to point out section 5. That's going to be very close to that Georgia form with the guardianship provisions. So you'll see guardianship provisions in section 5 of this form. And again, here a lot of the highlighting is just whether or not it's plural. Here, this section also allows you to name a conservator. So you could name your agent as a conservator. So what is a conservator? A conservator is someone who is going to make decisions for you while you're under this state regarding your finances. So you could name you can name your agent to also be your conservator under this document. Section 7, quickly in this one, very similar to Georgia. You can revoke this. You can change it at any time. You can write revoked on it, change it. And then if you start to go towards the end, I want to show you kind of each state here. If you go to page 11, that would be good. So yes, that's perfect. So you'll see these are kind of the signing requirements
Based on what state
you're on. So
Right.
if you then turn to page 12, you'll see Arizona's signing requirements. Keep going down, you'll see California's signing requirements. So that you can delete all the states that you are not in.
Right. Just sign the ones that pertain to you.
Right.
Yeah. Very, very helpful.
So just wanted to point that out.
Do you have any more questions? Okay. All right. So no questions on that. So I know you all need to just stretch. Woo! Do like 2 jumping jacks. Have a glass of wine, go use the bathroom, because now we need to transition. So
Yes.
we've gotten through part 1, and thank you for being patient. But I know that this is a lot, but we all know how important this is.